The Department of Home Affairs has made changes to the terms impacting temporary skilled migrants as part of Australia's migration strategy. Starting July 1, 2024, holders of employer-sponsored visas will have an extension to find a new sponsor as a result of these modifications. The Temporary Work Skilled Visa, Subclass 457, the Temporary Skill Shortage Visa, Subclass 482, and the Skilled Employer-Sponsored Regional Provisional Visa, Subclass 494, are subject to conditions 8107, 8607, and 8608, which are the subject of the legislative revisions. This video offers a thorough overview of the changing visa conditions and what information migrants, both present and prospective, should be aware of. The changes aim to provide temporary migrant workers more freedom and give them more time to move between companies. This change is intended to lessen worker exploitation and guarantee that those with valid visas may maintain themselves while looking for new job prospects. Key changes under the new visa conditions. The principal modifications under the new visa conditions are as follows. 1. Prolonged period of time for visa holders to find new jobs. When a visa holder quits their job with their sponsoring company, they will have a maximum of 180 days at a time, or 365 days altogether for the duration of the visa grant, to find a new sponsor, apply for a different visa, or make arrangements to leave Australia. 2. Visa holders' flexibility in hiring. Visa holders are free to work for other companies during this time, even in positions that aren't on their most recent authorized sponsorship nomination, as long as they aren't doing jobs that call for certain licenses or registrations that they don't have. Employment conditions for visa holders. Visa holders now have greater freedom as a result of these reforms, but there are some requirements they must follow while switching jobs. 1. Ceasing work with current sponsor. Unless excused, visa holders must quit from their sponsoring employer before beginning employment with a new one. 2. Compliance with nominated occupation. As long as they work for their current sponsor, visa holders must continue in the profession they have chosen. 3. Registration and licensing conditions. It is mandatory for visa holders to comply with all restrictions and regulations related to their employment, and not to operate in any capacity that requires special licenses or registrations unless they are in possession of those credentials. Visa sponsors have 28 days to inform the Department of Home Affairs of any changes to a visa holder's job position, including resignation, changes to the sponsorship status, and termination of the sponsorship. Key points to remember. One of the most important aspects of this new visa requirement is the notification period, which stipulates that a visa holder must disclose any changes in job status within 28 days. Details of the modifications, such as the visa holder's resignation, position changes, or sponsorship termination, should also be included in the communication. Sponsors of Australia visas must make sure that visa holders are adhering to the terms of their visa, especially with regard to work and licensing requirements. The validity of the visa holder's employment in their designated field while employed by an Australian employer must be properly verified. The visa holders are expected to have and keep any licenses or registrations necessary for the selected line of work. Impact of changes on current and future migrants. In order to guarantee compliance and provide assistance to visa holders throughout their transition periods, these changes call for an examination of sponsorship and employment policies. Furthermore, those who are granted a visa on or after July 1, 2024, as well as current visa holders, are subject to the modifications to visa conditions 8107, 8607, and 8608. It is essential to remember that the new timeframes specified in these revisions will not apply to any time a visa holder quit working for their sponsor prior to July 1, 2024. In order to comply with the employer sanctions provisions of the Migration Act, employers must closely supervise their employment of visa holders. Employers are prohibited by these regulations from permitting anyone to work without the proper authorization. That will be all in this video. Please share your opinions with us in the comments area. Don't forget to like, subscribe, and enable the notification bell to receive updates on job and immigration news. Thanks for watching. Good luck!